Hello viewers over the world. My name is Bombo Stewart. Some call me the legal prophet. I invite you in this beautiful episode where we are going to look at a very, very important concept in the laws that is in Uganda and laws in the country at large. So in this episode, we are basically going to have a general overview of what we call criminal procedure, or the laws in criminal procedure, or the laws of criminal procedure, as you may say, in Uganda, and of course in most of the common law countries. Of course, when I talk of the common law countries, I mean those countries that were colonized by the Great Britain, or what we call the United Kingdom. The laws of criminal procedure, as you hear, they are laws, and in these laws we see two words. We see what we call criminal, and we all know criminal involves the doing of an act which is a crime, or which is considered to be a crime, whether a felony or a misdemeanor. And then it can also be an omission. Failure to do what you have to do, it can amount to a crime. Of course, criminal law, as I may say, this is the law that is regulated, or that regulates the state and the people. That is the public and the people. Or it is what we call public law, or it is under what we call public law. Now, when you get criminal law, you studied it in your year 1. I think that is semester 1 and semester 2. Now, in your year 1, you studied what is an offense. How do they commit an offense? Okay. If they allege that you have committed an offense, what defense can you raise? You looked at the defenses of double jeopardy, the defenses of insanity, the defenses of infanticide, the defenses of diminished responsibility, as prescribed in the Penal Code Act of Uganda. However, now, at that stage we were not taught, or you were not taught, how a crime, or how someone who commits a crime is considered to have committed a crime. You are only taught the principles of criminal law, the presumption of innocence, that is the Wilmington versus DPP case, among other principles. But you are not taught, if someone has committed a crime, how do you go to courts of law? Or how does that person go to courts of law? At what point in time does that person raise their defense in law? So all that cannot be seen in criminal law, but rather it can be seen in criminal procedure. Now, as I was introducing, I told you that criminal procedure has the aspect of criminal and then the aspect of procedure. Now, basically procedure, literally everyone understands it. This is the process through which something is put into play. So now when you join the two, criminal procedure, you get what we call, when you join the two, criminal and procedure, you get the process through which the principles of criminal law are applied in courts. Remember back then, while you are classifying laws in Uganda and in the world at large, you talked about the classification of laws regarding to criminal versus civil. So with criminal, how to apply criminal law is through what we call the principles of criminal procedure. Basically, criminal procedure so much focuses on what we call procedural law. Remember, again, in your classifications of laws, you have to talk about the procedural versus substantive law. And we agreed that substantive law, basically, this is the law that is done at the bachelor's level. This is the law that particularly aims or emphasizes at someone having legal principles at their fingertips. Then the procedural law, that is the law that is done at the LODC, or the Law Development Center, where now you have to know, how do we put these principles of law into practical, or into the practical sense? Now, one of the elements or one of the key subjects that a learner should have to know that falls under the category of procedural law is what we call the principles of criminal procedure. Now, like I told you, without wasting time, I'm basically going to introduce the concept of criminal procedure and how it is applied. What do you expect? Now, in criminal procedure, you're going to see, basically, you're going to narrate. It is basically a narration on how does someone commit an offense. Not what is an offense, no. Okay, when he commits an offense, where do they go? Where they go? What does the role of police do? After police, where do you go? So that is the criminal procedure. So in this episode, we are basically going to talk about criminal procedure until where someone has been declared or has been convicted of the case. Remember, with criminal, we first of all begin with the principle or the presumption of innocence until proven guilty. That was clearly laid in the Constitution of Uganda under Article 28, Clause 3A of the Constitution, not forgetting the decision in Wilmington versus DPP. That is the first point. Someone is presumed innocent until proven guilty. Not in other countries, or not like in other countries that believe in the civil law or that go with civil law, that believe in the presumption of guilty until proven innocent, that when they say someone has done ABCD, they consider him guilty until he has to come out and prove to the world that, please, no, I'm innocent. Now, because criminal law is a law, or it is state law, or it is the law that regulates the state or the citizens and the government, or the public and the state and the people. In the community where we live in, we live with people. Someone can commit an offense against you. So we assume that someone has done an act. Now, when that someone does an act in criminal procedure, we shall call him a suspect at first. Why? I told you the principle or the presumption of innocence is very important. Now, if someone maybe stole my cattle, that someone is a suspect. Me, I'll become a complainant. Where do I complain? Where do I run to? I'll have to run to police. Now, when I run to police, we see a party. So all criminal proceedings at all levels or at most levels, they start from police. So police does not deal with civil matters. It only deals with criminal. So if you want to be compensated, or if your aim is to ensure that compensation is gotten from the other person, then you have to go for criminal. And with criminal, you have to go to police. Then if your aim is to put someone behind bars, then you have to go to police for criminal aspect. Then if you want to compensate, you have to go straight to courts to ensure that you pursue your civil remedies based on the principle of ubi jus ibi remedium, that where there is a wrong, there is always a remedy. So now, someone has stolen your cattle. You run to police. Police is the first party in the criminal process. Now, when you run to police, you, the person who has stolen, you become the complainant. And now this person who stole, or who you think, or who you allege that stole your cattle, or took away, or ran away with your cattle, will become the suspect. Now, when you go there, of course, you fill what we call police form 2B. I'm not going to go much into the police forms. You will record a statement, and with your statement, you, the complainant, police, of course, will require you to adduce or to bring the suspects or to present evidence. Now, when you get to police, you don't just go anywhere. You go to what we call the criminal department, the criminal investigation department, what we call the CID. Now, when you get to the CID, that is always a room that has different police officers seated within. Now, when you get there, of course, after recording, coming up, you record the statement in that visitors or that book that is always at the counter. Then they will take you to the CID department. And with the CID department, which we all know is headed by the OCCID, the OC station, by then the OCCID at that particular station, that person has a duty to assign which IO, who we call the investigating officer, who will have also a duty to ensure that is going to carry out the criminal investigation. So you're going to see that the purpose of police at this point in time is to carry out investigation. You who came as the complainant, your duty is now done. If you are done recording a statement with police, now police has a duty to carry out investigations, call out witnesses who are there, do whatever it has to do. I'm not going to go much into the evidence because there is a particular unit that talks about the different laws of evidence. So after police has done its investigation and police feels that it is sufficient, remember, while at police, a suspect, me, or a person who was considered to have stolen maybe the cattle, has gotten certain rights. And these rights are very clear under Article 23 of the Constitution of Uganda and Article 28 of the Constitution of Uganda. For example, this person will have a right to be visited by relatives at reasonable hours of the day. When I talk of reasonable hours of the day, I don't mean at night. So police sets the time when someone has to visit. So during the reasonable hours of the day, you can be visited as a suspect, right to be visited by their lawyer, and all other rights, as you will see in the provisions of the Constitution. Now, of course, that is at the point where now this person has been arrested. But while this person has been arrested, we can never forget the Miranda rule. That is the rule that someone has a right to remain silent, someone has a right to be visited, someone has a right not to exceed 48 hours while in custody. Of course, when we go back to the ground, that is practical way, you will see that even people can spend more than a month depending on the nature of the case. But the law, the Police Act will tell us, I think if I've not forgotten, around Section 25 of the Police Act tells us a person should not exceed 48 hours. Now, you will see what happens when someone is at police. While someone is at police, remember, is still a suspect. These people can always apply for police bond, which we all know as Police Form 18. So here, as a lawyer, if you are invited that, you know what, you have a client in custody, you have to go and pursue for what we call police bond. However, once police bond fails, that is within the 48 hours while someone is still in custody. Now, when the 48 hours elapse, you can pursue the remedies in Section 25 of the Police Act, that is as amended. That is either seeking the DPP's intervention, or you can as well apply for what we call an order of unconditional release from the magistrate that takes in the relevant jurisdiction where this person or where this police is, and the court will have to pass a decision to ensure that this person is released unconditionally. Now, while at police, before someone comes up in police, usually you will see that when people commit offenses, they at times run away. So when they run away, it is the duty of the police to arrest. Now the question is, how do they arrest? We shall see that in detail. But one thing I should tell police officers, if someone submits themselves, you don't need even to put handcuffs onto them. Why? Then that one will become arrest using excessive force. So arrest can be in different forms, as we shall see in the Criminal Procedure Code Act of Uganda, if I'm not mistaken, Section 2 of that very provision. That's when we shall see what are the different modes of arrest. Now we go back. This person, maybe you assume the 48 hours are done and police has gathered their evidence. What police has to do now, it has to take the file to the DPP. Now we see in the DPP. Now the question is, why are we talking about the DPP? And who is the DPP? The DPP is the short form of what we call the Director of Public Prosecutions. So the DPP, after the promulgation of the 1995 Constitution in Uganda, all power, basically all the power to commence criminal proceedings in Uganda as per Article 120 of the Constitution of the Republic of Uganda was vested into the Director of Public Prosecutions. Now the Director of Public Prosecutions for you in Uganda, he sits at NSSF building, that is level 7. Now when you go to NSSF building, that's where he sits, but he's one person. So what they do, they appoint agents who we now know they will call the state attorneys, obagwe Twitter state attorney. Now the state attorney at a particular area is known as the resident state attorney. Why is he called, or why is she called the resident state attorney? It is because it's the state attorney that deals with commencing criminal proceedings in that particular area. If it is Kawempe, if it is Nabweru, that is who we call the RSA. So now when the file comes from police, it goes to RSA. So if they tell you that now the file is from police, it has gone to RSA, you know that right now your police's hands are funked as official. Police's hands will be funked as official now, where police has, the RSA has sanctioned the file. So why does the police take the file to RSA? Of course, RSA is always a lawyer or a person who has practiced law, and policemen are not people who practiced law. The duty of policemen is basically to do what we call preference of a charge, or what we call preferring a charge. We shall see a charge sheet and the contents of a charge sheet. So a police officer just prefers charges according to the facts the complainant has told them. Now when the policeman prefers a charge, since they are not lawyers, at times they prefer wrong charges. And we all know, for you to sustain a criminal matter or a criminal case in the courts of law, you have a duty by law to prove all the elements of the case as per the Wilmington versus DPP case. So police prefers charges, but there are times where they prefer wrong charges. And if you prefer a wrong charge, of course someone will be acquitted. So the DPP has the duty to peruse the police file and ensure that the facts and the charges preferred by the policeman are in conformity with the law or will sustain a conviction, because the DPP or state attorney, their role is to ensure that someone is convicted. There is so much aim at conviction. That's when they assess their working. So at state attorneys, they will have a duty to peruse the police file. Now when they see that police file is complete, or the file or the case has been, or the evidence is sufficient, they will now sanction the file. Now when the file is sanctioned, it means that now the matter is ready to go to courts of law. Now when we talk of courts of law, we shall have to determine the jurisdiction. Jurisdiction, we shall have to look at so much the geographical jurisdiction and that jurisdiction regarding the penalty, where we shall have to look at the penalty. If the penalty, the penalty is so high, which courts we have to go to. Now, the matter will go to court, where after we shall have determined the jurisdiction. Now, when you get to the courts, we shall see that someone will have to plead. I'm not going to go so much into pleas, because we shall have to look at them in depth. Now, when someone is done pleading, where they plead guilty, of course, at that point in time, the judge can sentence and convict, or can adjourn the matter or the court and come up with a sentence. Then when the suspect has not pleaded guilty, we shall see that the suspect will have, or the lawyers of the actually now, when the suspect is in court, is no longer called, by the way, a suspect, is called an accused person. So now, right now, the accused person will have a right to apply for bail. We know all the provisions of bail in the TIA, that is the Trial on Indictments Act, if it is in the High Court, and in the Magistrate Courts Act, if it is in the Magistrate Courts. So bail can either be granted or cannot be granted. We shall look at the principles relating to bail. Now, after this, what will happen? Prosecution case will be opened. Prosecution's case, that is the DPP's case. And with opening of the prosecution's case, it involves just basically inviting the witnesses of the state. Remember, we shall later see the principle that was decided in the case of Mugo versus Republic, where they had to conclude that even a single witness can sustain a conviction in criminal. So it does not matter how many witnesses of the state or the state has brought. So the prosecution will open its case, and upon opening its case, calling all its witnesses, then we shall go into what we call examination. and re-examination of witnesses, where we shall look at the examinations in chief, where we shall look at the cross-examination, we shall look at the re-examination. That is if the prosecution desires to. Now, upon or after the examination is done on the prosecution's witness, then we shall go on to what we call the ruling on a prima facie case. The ruling on a prima facie case, that's like the ruling on a case or a no case to answer to determine whether the accused person should avail a defense, or there is need to avail a defense or no need to avail a defense. Because there are situations where the judge or the magistrate will see that based on the evidence or the witnesses of the state, we are just wasting time, and court will dismiss the matter on a no case to answer. But where the court says that no, it is incumbent that we should start the case, or a defense should be availed, now that's when now the defense will be opened. Of course, at this point in time, we are dealing with human beings, witnesses, and these witnesses, more so, they are always infringed. Some people infringe, or they go and begin conning them, and you find that we shall have to talk about the different witnesses that we have in law, where we have the refractory witness. And the refractory witness, that is a witness that comes up in court and basically refuses to testify or remain silent. We shall deal with who we call a hostile witness. That is a witness that you brought and later turns against you. So how do we deal with them? At that point in time, we shall have to discuss that into depth. Now, after the defense has been called upon, now the defense counsel will also have to adduce or to lay its evidence, either by way of calling witnesses, tendering in documents like exhibits, among others. Now, after the decision or after the defense has called or is done with its witnesses or its case, now we shall switch to the aspects of submissions. You come and talk the law. What does the law say? All that. It can either be written or not written submissions. After the stages of written submissions, of course, you must understand that the trial process in the High Court and the trial process in the magistrate courts differ in Uganda. So in the High Court, we shall see you don't just go straight. You have to first pass through the stage of committal proceedings, meaning that cases don't go straight to the High Court, no. They begin from the magistrate, you don't plead. We shall see the trial process in the High Court, the issues of assessors, all that we shall see at that point in time. Now, when we come back to the process where now the witnesses have been called, the prosecution has laid its case, a case to answer, no case has been seen or done by the magistrates and the parties herein, we go to the aspect of submissions. After submissions are done, now we shall go to the stages of convictions. We shall go to the stages of convictions. We shall go to the stages of judgments. And after judgments, that's when we shall see that now someone has either been convicted, who is now a convict, or someone has been acquitted. So that is the stage of criminal processes. Now we shall see that what happens after someone has either been convicted. They have rights of appeal. So we shall have to look at what we call the post-trial processes, which involve appeals, which involves revisions, which involves review. So after we're done with that, we shall say that now we have done some kinds of criminal procedure. As I'm concluding this episode, I want you to note that criminal procedure is very, very important, or it is a very, very important concept in law, that if you don't understand it and you intend to become a criminal lawyer, or we call the devil's advocate in the practical sense of the law, you might not become one unless you've grasped or you've mastered the principles of criminal procedures. I remain Bomboka Stewart, alias or also known as the Legal Prophet. Let's keep the Legal Prophet, and we'll wait for the next episodes. Thank you very much.